this is Michael Keppel, the Managing Director of Lakeland Advisory Group. During our podcast series, we talked about a range of technology and solutions to improve professional services. And it's my great pleasure to introduce Damien Riel, who has focused on artificial intelligence. I know we had a couple of conversations about artificial intelligence on these podcasts in the past, but Damien's product, which will hopefully be able to show you a little bit of it, what it can do, is most amazing. Artificial intelligence has come a long way over the last 18 months. It's grown geometrically, and you can't pick up an article or paper or book about reading about AI. But Damien and his team have taken that talk into an actionable solution, of which we'll be very proud to demonstrate to you. Without further ado, I'll let Damien give you a background about what his services are, what he's done, and a little bit about himself. Please
Sure.
go ahead, Damien.
Sure. I'll start with myself. I've been a lawyer since 2002. I worked for the chief judges of state and federal district courts. I also worked for a big law firm, Robbins Kaplan, where I represented a large retailer here in Minnesota. I represented victims of Bernie Madoff, where there's a lot of forensic accounting, as you can imagine, in that representation of Bernie Madoff victims. And I also helped sue JP Morgan over the mortgage-backed security crisis of 2008. So I did high stakes bet the company litigation, but I've also been a coder. I would say an awful coder since 1985. So I've always had the law plus technology background. And so I left the practice of law after about 15 years to be able to join Thomson Reuters, where I helped them build things. I did a stint in cybersecurity where Facebook hired me and my company to investigate Cambridge Analytica. So I spent a year of my life on Facebook's campus with their data scientists and my former FBI, CIA, NSA people, and we figured out how bad guys use Facebook data. But since 2019, I've been with BLEX, where we have 1 billion legal documents. That is all the cases, all the statutes, all the regulations, as well as all of the district court motions, briefs, pleadings, orders. And I maybe have the coolest job in legal tech, where I get to do data science on those 1 billion legal documents, extracting everything that matters, and then running large language models across them to do everything that I did as a litigator for my 15 years of practice, as well as all the transactional lawyers and what they do too. So we collect all of those into what's called workflows, and then we essentially we do the prompt engineering so you don't have to. So if you upload a PDF, say a complaint, we will give you 200 pages worth of analysis from that complaint, and that 200 pages reflect what I did as a litigator at Robbins Kaplan for all the complaints I received. So these are exciting times with the law, because everything we do as lawyers involves words. That is, we ingest words, we analyze words, and we output words. And it turns out large language models can do all three of those things at superhuman speed and at a postgraduate level. So these are exciting times.
Damien, I think that's one of the many things we have in common. We both were coders. In a previous life, I started out as a technologist and as a coder, and it helped me really appreciate what the technology can do. Now, I don't want to date myself, but going back to code, you were so limited on what it can do. Now, if you could take that code and marry it and couple it with artificial intelligence and the voluminous, almost endless databases out there, there's no stopping technologists today. And
that's right. Yeah, and I would build upon that to say that, yeah, you and I, I'll say that I was a mediocre coder at best, where it would take a very long time to be able to code things up. But it turns out that large language models have ingested the entire internet, so they know everything about coding. And so in the old world, what I would do at Thomson Reuters, for example, is that I would write up requirements. I would say, I, as a subject matter expert, I, as a lawyer, need the software to do these 25 things. And those would be requirements that I would then hand off to the software team to be able to build the things I described. But that was the old world. But the new world is the requirements are the software. That is my description is the prompting that goes into the large language model. And then the coders call this vibe coding, where you just say, I want the software to do these 25 things. And then things like Claude Code and things like Cursor and things like Windsurf. These are programs that take my English descriptions and turn them into, Python, or turn them into, COBOL in your day, right? So this actually, because it knows Python, it knows COBOL, it knows JavaScript, and it'll actually code up a full application based on my English description.
And it's come a long way, as you said. Coding is now much more strategic, because you have to think, okay, how am I going to manage all this information? How am I going to do this? It's totally different than, as you properly stated, I was a COBOL programmer going back in those days and doing that. And it's apples and oranges now. I shouldn't even say that. It's not even the same fruit. One's a fruit, one's a vegetable. It's changed that much geometrically. The one thing I had the pleasure of looking at your software, as you know, previously, and the one thing I think needs some proper attention in the past couple years, as AI has been taken off, so many people have been reading about the challenges of hallucinations. Where the AI tries to solve problems that don't exist, or the AI tries to give everybody equal weight on the internet, or that the answer you get from AI is incorrect. That's very simple. It's just, it might have 90% of the material spot on, ready to go to court or to your client, and the other 10% it fabricated. And if you could talk a little bit about how you were able to mitigate, actually eliminate, that very serious problem with AI.
Yeah, as a litigator for 15 years, I know that you often, like any storyteller, want to show, not tell. So if it works for you, maybe I'll show and tell at the same time. That really, when we think about hallucinations, that is a lack of being able to have the ground truth. That is the actual case that you're talking about. So this is Vincent that you can see here, and everything a lawyer does is a workflow, whether it's asking a research question or building an argument, or uploading a contract and getting 200 pages worth of analysis, or uploading a complaint and getting about 200 pages worth of analysis, no prompting necessary, doing a full 50-state survey, or doing a multi-country survey. So each one of these is a workflow. And to your point, if I were to ask, we'll go with number one, ask a research question. If I were to ask a research question of ChatGPT, that's a bad answer, bad idea. And Steve Schwartz out of New York will tell you why it's a bad idea. It's a bad idea because it might hallucinate cases. It might hallucinate statutes. And even if it gives me a particular statute, like it does here, it doesn't give me a particular language from that statute. And even if it does give me language, it might be hallucinated. So if I need to do the research anyway, what's the point of doing it in ChatGPT? So let's ask the same question here, but let's ask it across actual California law. So now I'm going to hit select, and I'm going to say, tell me about trade secret law regarding former employees, stealing customer lists. And what Vincent does is it searches through actual non-hallucinated cases, actual non-hallucinated statutes and regulations, non-hallucinated administrative decisions, as well as secondary materials from the law reviews and American Bar Association. So right now you can see it's already found 48 potentially cases, statutes, and regulations. And then it's begun a 5-stage review on 29 of those. That 5-stage review, stage 1 of that 5-stage review, is to find actual non-hallucinated text from actual non-hallucinated statutes and regulations. So this text and also non-hallucinated cases, like you see here. So the text that you see highlighted here will be non-hallucinated 100% of the time. And the case that you see here will be non-hallucinated 100% of the time. And those who know large language models might be wary, saying, hey, Damien, how can you say 100% and not 99%? And I can say 100% because this text was not created by a large language model. This text was a database search, like we've been doing database searches for 40 years. So this text is non-hallucinated 100% of the time, and this case will be non-hallucinated 100% of the time. So we provide you with the ground truth of the case's text that actually answers your question. So we give you the portion of the case that answers the question most directly. So that's stage 1. Stage 2 is then we ask the large language model, how well or how poorly does this text answer the user's question? And here's how well or how poorly MoreLife answers the question. Here's how well or how poorly American Paper answers the question. So we give you individualized analyses of every single case, statute, and regulation. That's stage 2. Then stage 3 is we actually give you a confidence score to be able to say that this case 90% answers the question, but this other case 100% of the time answers the question. So ReadyLink is totally on point, whereas American Paper is mostly on point. So stage 3 is giving confidence scores. And then stage 4 is we say, well, if a case like Neville answers the question, or if a case like, we'll say a Supreme Court case, let's say here, Supreme, or courtesy temporary services. Let's say that one. If that case answers the question, then maybe the case that this courtesy cites might also answer the question. So we go through all of these cases and we do that same stage 1, 2, 3 process on all 3 of those cases. And if any of those are above a 70% threshold, we add that to the list. And then we also go up the tree to be able to say crafty cites courtesy, Uniform Trade Secret Act, and intellectual property cites. So we do the same stage 1, 2, 3 process on all 87 of those. So we give you the ground truth, we give you an analysis of that ground truth, and then we turn everything into a memo that you see here. And this memo gives you the short answer on top. This is like I told my associates at Robbins Kaplan. I would say, don't make me wait to the bottom to give me the answer. Give me the answer right up top. And Vincent will do that 100% of the time. Then we'll give you a more fulsome summary. And then we'll give you the background statutes. That is, how is trade secret defined? What is misappropriation? What are the remedies? Can you get an injunction? Can you get damages? What are criminal penalties? What procedural requirements do you need to do? Which cases talk about customer lists as trade secrets? And here are non-hallucinated cases. And here are elements of the claims and remedies. So this is probably, and still working on it, but this is probably going to finish in about 30 seconds or so. And so if you think about how long it would take a human to read through hundreds of cases, land on the 22 and 12 statutes and regulations that are above that 70% threshold, and then turn everything into a memorandum, probably going to take that human longer than the 2 minutes it's going to take to build this memorandum, which is probably going to be a 50-page memo. So when
you've been able to take the research changes, a paradigm shift with regards to how one does research in the legal. And I might also add, as I know that this tool also does bankruptcy cases, and I spend a significant amount of time on my bankruptcy research, but it changes the entire workflow of the documentation. And I think the most important part is it takes all this voluminous data, which you control and sift through and make sure is pristine, and change it into meaningful information in a timely manner. It changes the way people have to do business. Now, that's I know right. you and I talked previously, is that a big challenge is the change of people to see the workflow. There's a lot of information out there that a medical physician will use throughout his career, whatever he's learned in med school. And it's very hard to get a paradigm shift into something like this. How are you able to get the attorneys to think outside the box and recognize the AI as the tool? And what do you see as the next step in utilizing something like this?
Yeah, I think the first step for lawyers is to know that it's out there. That is, so many lawyers are so busy doing their work that they don't look up and see the tools like you see on your screen are out there. So step one is for them to be aware that the tools are here. Step two is to realize that if I'm doing my job correctly, you won't have to be a prompt engineer. All you'll do is you'll ask this question, which is the same kind of question that a partner would ask an associate. Tell me about the trade secret law regarding former employees stealing customer lists. This is not a prompt. This is just a question. And what you don't see in the background are the 35 prompts that my team and I have built to be able to give you the good output that is right here. So if I'm doing my job correctly, you won't have to be a prompt engineer. You just do your work like you usually do. You ask the question like you would an associate. And the third thing that I would say is that a lot of the getting people to change their mindset is to be able to see that if I'm doing my job correctly, all you have to do is upload a PDF like this complaint. And Vincent will recognize, oh, that's a complaint alleging copyright infringement. And based on that, Vincent will give you all of these buttons, no prompting necessary. And these buttons reflected what I as a litigator did for every single complaint I received. I would say, what are the claims being alleged? What are the facts supporting those claims? Who are the parties? What are they looking for? Are they looking for money or are they looking for an injunction? These are all extractive tasks that we give to you as a lawyer, no prompting necessary. And then we go back beyond extraction to ideation. What legal defenses can I mount for each claim? What questions should I ask my client to help them win? These are the work of the lawyer. And then there's legal research questions that are customized to copyright. So for copyright, maybe you want to know about statutory damages and actual damages and fair use and transformative use. We give you these all on the fly. So really, you just upload the PDF and we give you about 200 pages of analysis, including the memos on actual damages and statutory damages, the memo on infringement, the memo on all of these things. So this is about 200 pages worth of analysis, no prompting necessary. So the theater of the possible.
That's one of the major differentiators of Vincent, your tool. Is it versus some of your competitors and other AI tools out there, quite candidly, is your solution was developed by attorneys who knew what they had to do and what the average attorney in court required. It wasn't done by a bunch of kids in Silicon Valley looking for a solution to solve.
That's
And
exactly right.
yeah, that's the significant difference. Being an attorney and going through your professional career, what the partner needs. You know what the court's going to need. You know the format. You know what's acceptable, what's not acceptable, and that's a differentiator. Now, if you just use ChatGPT, and it's a great tool, and it's done so much for the industry, but you're not going to get the same result because it's not customized. It's not developed, and it's by attorneys for attorneys, and that's the differentiator.
That's one of the many differentiators. Yes, it was developed by lawyers for lawyers, and like I said, these are things that I did as a lawyer every single time I received a complaint. And it's also, we have some of the best legal technologists on our team in the world. I've worked at some of the biggest companies in the world in legal tech, and these people code and they ship. So the idea is that, yeah, we do everything that a lawyer wants because we are lawyers, both on the litigation side and on the transactional side. If you want to do a contract like a merger agreement, we'll give you different buttons, no prompting necessary. And that's because we have contract lawyers on staff. And so really, because we say, okay, I know exactly what it needs for a deposition. Here's a deposition where I upload it, and we give you all sorts of things like a timeline of who did what when. We give you the particular issues and themes in the deposition. We show you trust but verify aspects of it, where you can say you hold yourself out as an expert. I can't imagine someone being more of an expert. And then we give you stuff that you can put into a brief, pleading, or motion. He claimed to be an expert due to his success. Question from the lawyer, response from the deponent, page and line numbers, and again, trust but verify, so you can be able to do this. These are all things that I wish I had when I was litigating, and now we give this to you, no prompting necessary. So yeah, I think these are exciting times.
These are definitely exciting times. And the world of AI has changed geometrically in the last 18 months. And I go back to 18 months. That's when I started playing with it, for lack of a better term. And I always had some problems with hallucinations, which you were able to overcome in early AI. Given that you spent so much of your career and your life playing with this AI, where do you see it going in the next 18 months?
I think that we are going to continue building out workflows. That is, everything a lawyer does is a workflow, whether it's a research question, building an argument. This is something that I haven't shown yet, but is quite powerful, is that everything I do as a lawyer is applying my facts to the law. So I put in my facts here. I say that I represent Sarah Johnson, and she met with her former employer, the jerk Michael Brown, who decided to record. After she provided sensitive personal details, Mike put a smartphone on the table and started recording without Sarah's knowledge. So I then say, here are my facts, and then here are my goals. I want to show that his recording of our conversation without consent violates the privacy laws. So everything a lawyer does is applying my facts to the cases, statutes, and regulations. And so now we find the most relevant cases, statutes, and regs, and we say, here's now an argument, a one-paragraph summary, applying the facts to the law. Here are the most relevant facts that I gave. Here are the most relevant statutes, the federal statutes, the state statutes, the state causes of action with the non-hallucinated cases that support those. And then everything a lawyer does is applying law to the facts. Because the defendant recorded the conversation without the plaintiff's consent, under the principles of this statute, it's likely it violated privacy laws. And there is reasonable expectation of privacy as established by Katz and by Jones. And now this is now draft an email to my client, a CEO, describing this in lay terms. This is me prompting to be able to say, I want this. And now here's an email summarizing the actual cases, statutes, and regulations. So I think that, you asked what is our next 18 months going to be. My next 18 months is now to take these arguments and to concatenate the arguments into a motion. So you could actually do a full motion with all of my facts, and you could be able to say, yes, it violated privacy laws. And here are 4 other causes of action that we will then just pull together, much like I did as a lawyer creating a brief. So today we can build arguments. Tomorrow we can build briefs and complaints and answers and.
Over the last 100 years, or maybe even for longer than that, I think there's been 3 major issues that changed the way the world works. One of them, transportation, was the first one. We got rail We got planes, we got the interstates, we got a whole host of means of transportation, especially in North America. Secondly, when the computer came out, in many regards, Bill Gates was correct. Everybody's going to have a computer on their desk. Most people have more than one, if you consider the phone as a computer, which it is. And the third thing that I think is the paradigm shift for all mankind is AI. What do you see as this change in the role of an attorney or a professional in general, Damien, being as a result of having AI now?
Yeah, I think you're right. And I think that your mention of Bill Gates is absolutely the right one. And there's actually here's on your screen, you can see that he said he's overseen 3 revolutions, one of which was the PC revolution, where there is zero marginal cost to be able to duplicate things. You can make one email or, print out 100 copies of that. The second was with the internet, where you could distribute one email or 1,000 emails, or you could do Amazon can go to 100 countries. So now the third is AI. And now there's zero marginal cost for intelligence to ideate things. And now you can ideate and distribute for zero marginal cost. So I think that that's true. And now translate that to lawyers. There's zero marginal cost to be able to have, you could have one associate, and then that one associate could have tools like Vincent that could have 10,000 associates underneath them that is doing the work of 1,000. And so I think that that is going to change lawyers to say that you used to have a massive law firm in the middle of Manhattan with hundreds or thousands of lawyers and many staff underneath them to be able to try to have a semblance of good work product. But today you don't need that big law. You could jump ship. That as a lawyer could jump ship and start their own firm, a boutique with maybe 5 lawyers, and have their 10,000 lawyers associates underneath them. That is their 10,000 large language model associates underneath them. So I think that this is for the big law folks that get it. They're now adjusting to this new reality. And for the small law lawyers that want to be able to do the work of the big law lawyers, but with a smaller staff and lower overhead and more profit margins, they have a really good opportunity too.
Now, many technologists and people, and you coincidentally show the same thing with Bill Gates, see a lot of great things going on with AI, a lot of great things, especially in the medical world. They have gene matching, DNA matching now takes seconds, which used to take weeks to get done. Just phenomenal. Mm-hmm. What do you see as the challenge for professionals with regards to AI in the future? We talked about all the great things, and there have been a whole slew of great things, Damien. What do you see some of the concerns or challenges?
Well, I think that, the reality that every lawyer is going to be thinking about is what can I do that's better than the machines? And we as lawyers think that our product is the documents we produce. So, for example, if I'm a contract lawyer, I say, okay, I'm putting out widgets. But already the tools, the machines beat humans in, say, contract review, where humans are about 93% accurate, whereas the machines are about 95% accurate. Humans take about 200 minutes versus the machines taking 4 minutes. And the cost per document, humans are about $76, whereas the machines are about $1.25 down to 2 cents. So already, and by the way, this is 2023 numbers. In 2023, the machines were already 300 times cheaper and more accurate than the humans. And so this is what you're really up against. And this is the worst the technology will ever be. So as we think about, what do we as lawyers provide? We don't provide the widgets. What we actually provide is trust. That is, the client comes to me not to be able to crank out the widgets, but for me as a human to say to you, you are maybe going through the worst time in your life. I am here for you. Your problem is now my problem. I'm giving you trust that we're now going to handle this thing together. So that trust is really what the clients are paying for. The clients aren't paying for the brief. They aren't paying for the contract. What they're paying, even though those are necessary parts of our work, what they're actually paying for is that they trust you to make that brief good. They trust you as a human to be able to make that contract good. So really that I think that trust aspect is something that we are going to need as lawyers to be able to up our game in. That is our bedside manner, our humanity. As the machines that I'm building and others are building do more of the widgets, all that's going to be left is our humanity. And the rainmakers for many years already know this. Another name for rainmaker is good salesperson. And we know that a good salesperson has the rapport with the client, with that humanity.
But they do. That's very interesting that you've mentioned that, Damien, because the challenge is, especially for my world, dealing with CPAs and business valuators, A lot of the people are fantastic at number crunching, but they don't have that human skill. And this AI can do the number crunching and the analysis at lightning speed in comparison to anyone. But you need that personal skill to go to the next level. So I think that's a paradigm shift among professionals, whether it be medical, CPAs, lawyers, or whatever, is how you deal with it, because your differentiator is no longer cranking out a financial analysis, or in your case, a contract agreement, because software can do that, and we can all be using the same software. How you control the software, how you communicate to your client is the differential in that scenario.
That's exactly right. And I would add on that is that there are some things that the machines are really good at because they have the data. That is, we have the cases, we have the statutes, we have the regulations. So I am able to crank out a brief that has those things really quickly. What my tool doesn't have is what's stuck in your brain. That is what happens in the closed door negotiations that aren't in any data set. That then I could be able to use that knowledge that's stuck in my brain and be able to apply it to those cases, those statutes, and those regulations. And those two together are going to be better than the either of them separately. So that's thing number one. Thing number two is that as a paradigm shift, we have to be thinking about how we bill. That is the business of law. And there's an old joke that the slowest lawyer wins the race, because if we bill by the hour, and then we bill by the hour. If you take 10 hours to do a thing, that takes me only 1 hour to do a thing, you're going to make more money than I do. But that's not true. That is true for hourly billing lawyers. But who it's not true for is for contingency fee lawyers and flat fee lawyers and subscription fee lawyers and success fee lawyers. It's also not true for in-house corporate law departments. It's also not true for government lawyers like attorneys general and prosecutors and public defenders. For all of them, they love efficiency because they have more work than they have time. And so what I think that we as lawyers need to think about is, if I can, that complaint example that I gave you, that tool that we built, that takes about 200 hours worth of lawyer work and shrinks it down to about 5 minutes. And so how does the billable hour really compete with that? If you have contingency and flat fee lawyers that are going to be able to say, I'm going to use that AI to shrink my cost to increase my profit margin. So I think that.
Do you think the hourly environment will start disappearing for professionals as a result of this?
I think that the hourly billing will never go away. It won't go away completely. But I think what will happen is the current 90% billable hour revenue from a law firm and about 10% flat fee will maybe flip, where it's going to grow from 10% to maybe 20% flat fee to 30% flat fee to 50 to 60, and maybe kind of hover around the 60 to 90% flat fee that the big four accounting firms do. Because the big four accounting firms say we now have systematized those 60 to 90%, and only the most unpredictable things we bill by the hour. So I think the hourly will not go away completely, but those who figure out that the contingency fee and flat fee is going to be able to make more money, I think that is going to be the way of the world. And this is actually something that I'll show you in this slide here, is that there's when we think about lawyers, and this will probably your accountants in the area will love what I'm about to show you right now, is that if you think about hourly, most of our lawyers think in hourly. We think, how much revenue did we bring back the last quarter or last whatever, but we don't often think about cost, because revenue minus cost equals profit margin. We all know this, right? But if you switch over to the flat fee side, you realize if I press down my cost using AI, I can make more margin, make more profit. And I can make so much more profit that maybe I can shrink my flat fee to be able to say, hey, client, I'll give you this. And the client says, wait. Not only do I pay less, but I get the certainty of a flat fee. Bring it on. So now I, as a lawyer, make more money and the client pays less money. And if the client doesn't know what that top line is, you can actually push the number up and actually make more profit. Once you move over to the flat fee world, you can actually make way more money. And now that you've done this, I did plaintiff side antitrust work, where some things I sued about were price fixing. And inevitably, one of the people would drop their prices. And what would happen next is that they would steal all of the customers from their competitors. And then what would happen next, of course, is that everyone would drop their price, right? This is how price fixing cabals go away. We don't have a price fixing cabal, but in lawyers, legal practice, but we do have an hourly billing cabal. And many law firms that I'm talking to have said, I can make way more money using flat fee. And what happens next is they steal all the customers, all the clients from their competitors. And then what happens next? Of course, everyone's going to jump onto that bandwagon. And the question is, do you as a law firm?
That's a challenge, though, Damon, because once a couple of people you start utilizing it in order to be competitive, you got to use the same tools. I mean, you can't do it the old way when someone else you're competing with in a different floor, a different building, is using Vincent or some other AI tools.
That's exactly right. And so the question is, do you want to use those tools and be person number 1 on the screen? Or do you want to be person number 5 on the screen that doesn't know why the phone stopped ringing? That is, the client's not going to tell you why they stopped calling you. They're just going to stop calling you. And you might blame, the economy or blame the, the client's, sweetheart deal with the other side, but you won't know if you don't use these tools. You won't know why the phone stopped ringing.
No, that's very impressive. I assume it took you several years to develop the Vincent as you were going along with AI to keep integrating all these modules.
See, yes and no. So I would say yes. Vincent has been around. Well, I guess VLEX as a company has been around since the year 2000. And its predecessor company, Fastcase, has been around since 1999, since the 1900s. So for 25 years, both of these companies have been collecting cases and statutes and regulations. And there are only 3 companies in the world that have yesterday's case, yesterday's statute, and yesterday's regulation. Those are Thomson Reuters, where I used to work, LexisNexis, and us at VLEX. Those are the only 3 companies in the world that have this. So it's taken 25 years to amass this data set of cases, statutes, and regulations. And then now we can use that treasure trove of very precious data to be able to build Vincent. And I would say that the yes part is that it's yes and no. It's no. It's yes, it's taken a long time, 25 years to amass the data. And no, it hasn't taken much time at all to build Vincent. That is because once you have that data set, you could be able to prompt and be able to do, if you build a system like we have at Vincent with the brilliant engineers that we have at VLEX, they've created a system where I can now make a workflow in about 25 or 30 minutes. And so
that's a key advantage, Damon, and people have to realize, our audience, is that's why Facebook and Google, they want all the information. It is the historical information in the trends. That's the secret sauce. With AI, you can slice and dice that voluminous data in a meaningful way for your audience, but it's the data. And in your case, in your firm, you have 25 years, a quarter of a century of information you can instantaneously tap into and know and the important part is know the validity of said information.
That's exactly right. And not only the validity of the cases, statutes, and regulations that were decided yesterday, but to also know that Roe v. Wade is no longer good law because it was overruled by Dobbs. So we also have that ability at VLEX to be able to say that Dobbs overruled Roe v. Wade. And if ChatGPT doesn't have yesterday's case, they won't know that the data in ChatGPT's data set is old, that they might say that Roe v. Wade is good law. So that's thing number 1. Thing number 2 is it's not only appellate cases like Roe v. Wade, but it's also district court cases. That is the case that your judge decided yesterday that might be just like yours. We also have that data. We have 905 million dockets and documents across all the federal courts and 38 state courts, including your court where you're in today. So I can say, what are the odds of winning this motion to dismiss for breach of contract in front of Judge Smith in the Southern District of New York? And we have all of Judge Smith's breach of contract cases. And so we could say, Your Honor, this is just like the case he decided yesterday, or this is just like the case he decided last week. If you have that data, which we do, we're able to give you essentially a universal document management system, not just of your brief bank in your firm, but of all the firms that have ever filed anything in all the federal courts and 38 state courts. The data is the thing.
I'm convinced that you've not only demonstrated to me, and I have a previous demonstration of Vincent. What's the next step for those many people who are going to be interested in this? They just reach out to you and you give a demo. What's the process to show them the solution in a more detailed format?
Yeah, I've given. I'm quite busy, as you can imagine. So in 2024, I gave about 120 presentations, and I took about 90 flights. So my time, I probably won't be able to give a one-on-one demonstration, but what I'll do is I'll give you a link to our trial page, where the proof is in the trial pudding. So what your listeners can do is they can have a 3-day free trial where they can actually kick the tires of Vincent and be able to upload complaints, upload contracts, upload depositions, ask questions, and I think that, just like a picture is worth 1,000 words, I think a demo is worth maybe 200 million words or so.
Excellent. Damon, thank you so much for your words of wisdom on this fascinating topic with regards to AI and its ramifications on professionals. Have a great day. And again, thanks, Damon. Looking forward to working with you in the future.
Thank you so much. Likewise.